Today is February 27th, 2025, and welcome to the New Possibilities Hour, part of the Will Work for Food project founded by Natalie Armstrong-Motin. Every Thursday morning, Jean Lawler and I are delighted to co-host another installment, another webinar for mediators, arbitrators, lawyers, and everybody who negotiates. As you likely know, there's no charge for these great presentations. Rather, we ask you to contribute to a food bank if you like what you see. And in the almost 5 years we've been doing these webinars, our audiences have been so very generous in contributing in honor of our great speakers. One of my favorite parts of each week's presentation is when we announce the running total of just how much people have contributed to fight food insecurity worldwide. Jean Lawler, would you please do the honors?
With pleasure. Thank you, everyone. Hello, everyone. Good morning, good afternoon, good evening, wherever in the world you might be. I'm so happy to say we have been told of donations to food banks around the world of $692,384.34. I mean, that's millions and millions of meals served. So thank you all for your generosity. $750,000 is really getting close.
Fantastic. Thank you so much, Jean. And today we have a wonderful presentation on tap from Jonathan Anschell. Jonathan is the Executive Vice President, Chief Legal Officer, and Secretary of Mattel. He's Barbie's lawyer, and he's going to talk to us about negotiation back to basics. Jonathan, if you would please tell us a bit about the food bank to which you would like people to contribute if they're in a position to do so, and then on with your presentation. The floor is yours.
Thank you, Jeff, and good morning, everybody. My food bank of choice is the Sova Food Pantry here in Los Angeles, but I would encourage everybody to donate to the food bank of their choice. And I want to thank Jeff and Natalie and Jean for the invitation, and also really to congratulate you guys on just a fantastic program. I've been seeing this unfold with the online updates as you've been doing it, and I really think it's a wonderful way not only to bring people together to talk about some of the issues we'll be talking about today, but also to raise money for the cause of food security, which is so important in our community and so many others. So congratulations on that, and thank you for letting me be a part of it. As Jeff said, when we were talking about a potential topic for this morning, one of the things that we landed on was a back to basics review. I know from having seen some of the other topics that you've talked about before and knowing the group of people who are on the screen that you're all familiar with negotiation techniques. You've heard from many top negotiators and top advocates as part of this series. Even in that context, sometimes it's helpful to take a little bit of a step back, kind of return to the big picture and review first principles. So that's what we'll be doing in the first half of our conversation. And then I'd be delighted to take any questions and to hear from you. So with that, let me go ahead and try to share my screen, which I will say is always somewhat precarious when I'm operating the PowerPoint, but I think we can manage to do it. Okay. Can you all see the screen at this point? Somebody give me a thumbs up and we'll know that at least I've gotten us this far. I'm now going to move us into slideshow mode. Excellent. Okay. So with that, as I said, our topic is back to basics, navigating conflict and finding common ground. As all of you know, that is really a long-winded way of referring to negotiation, which in the scheme of things is really a very, very broad topic, because even outside the context of mediation and ADR and negotiation in the course of a legal transaction, all of us negotiate every day, because it's the act or process of having a discussion in order to reach an agreement. So a lot of what we'll be talking about today applies in a number of different contexts. And as all of you know, there's a lot that has been said and been written about the topic. And I have on the screen here on the right side, just a few examples of some of the books that many of you have probably seen or read that are among the leading titles in the field. There's really sort of the grandparent of them all, for those of you who study this stuff, Getting to Yes, And of course, just like the Barbie movie, any big hit needs a good sequel. Then there's Getting Past No. And then a few others. One of my favorites is Never Split the Difference, which is written by a former FBI hostage negotiator. And then another oldie but goodie, You Can Negotiate Anything. So this is a field that has certainly been studied and written about. One of the things I think it is always helpful to start with is the nature of a relationship before there's conflict or negotiation, and the importance of rapport in that relationship. So we see a couple definitions here on the slide, and Webster's tells us that rapport is a friendly, harmonious relationship, especially one characterized by agreement, mutual understanding, or empathy that makes communication possible or easy. All things that are obviously vital in a negotiation. And then if you prefer something more from the world of self-help and pop culture, Tony Robbins tells us that rapport is the ultimate tool for producing results with other people. And that no matter what you want in your life, if you can develop rapport with the right people, you'll be able to fill their needs and they'll be able to fill yours. So we see coming from a number of different sources the importance of the nature of a relationship before you get into a negotiation and the benefits that having a positive rapport can bring us. There are some examples. The question then becomes, okay, if rapport is important, how do we build it? One example, going back even to the pre-pandemic days, is a meal or a drink or a cup of coffee. Doesn't need to be anything more formal than that. But of course, the world of technology and the things that we've developed and come to rely upon since the pandemic have given us some other tools as well. Getting together on Zoom, just having a quick chat with somebody, a Zoom coffee or a cocktail. So if you're not able to meet with somebody in person, if you're in different cities, sometimes it's helpful to see somebody face to face, even if that's just on screen. And you don't necessarily need to be doing all of this in real time from the standpoint of rapport building. Sometimes just a congratulatory note or an email. I'll give you an example. If you're, for example, litigating a case against an opposing party or negotiating against an opposing party, and you see that they've had a good result in another matter, nothing wrong with sending an email to congratulate them. Nothing wrong as well with sending them something that might be of interest just to maintain a relationship outside the four corners of the specific negotiation that you're going to be dealing with. The same goes for something like a helpful heads up or some interesting information that you thought they might benefit from. So there are many, many other examples. These are just a few tools of the way that negotiating parties can establish rapport before a negotiation and even during the context of handling a negotiation, whether that's a deal or a dispute. Taking the relationship outside the four corners of the dispute resolution process and building or maintaining rapport on a human level can have a lot of benefits when you get back into the negotiation itself. And we'll talk about a real world example of that in just a minute. One thing that I found interesting is that recently the importance of rapport and some of the get-togethers that I referred to in a minute has been recognized by the courts. And this came up late in November. There was an order in the Northern District of Alabama from Judge David Proctor, who ordered the opposing lawyers on a case to go to lunch together and then to file a joint report regarding that lunch, which is exactly what they did. So you see in the court order itself, it says further, the court orders that on or before December 31st, counsel for both plaintiff and defendant are to go to lunch together. And the judge, in fact, went so far as to divide up who would pay the bill and who would pay the tip. And then you can see over on the right that the lunch had its intended effect because the opposing lawyers reported on the fact that not only did they go to lunch, but they talked about their families, they talked about the practice of law, they talked about big ticket items for the holiday season, their small town bona fides, and also the plan for communication and dialogue going forward. Because not surprisingly, the backdrop to this court order was a breakdown in the relationship. And so the judge, rather than deal with the matter, strictly speaking, through the motions that had been filed and the intervention that the parties were asking from the court, the judge instead ordered them to go to lunch together. And one can only imagine that, having gone to Saw's Barbecue in Hoover, Alabama for over an hour, talked about their families, their plans for the holidays, and developed a plan for communication, that the court order had its intended effect. So it's interesting to see not only negotiators, mediators, and others recognize the importance of rapport, but in this particular instance, the courts as well. And as I mentioned, this can have practical benefits and dividends for all of us. And I wanted to share a personal story of the benefit of rapport, how it can help cut through impasse and lead to the results that we're all looking for in negotiation. Shortly after I got to Mattel, we were trying to resolve a dispute where there were a number of different parties involved, and we were the lead party on the defense side. And we believed we had a settlement at hand, a number coming from the plaintiff, that from our standpoint was a reasonable way to settle the case. Problem was, in our own allocation of responsibility and our valuation of the amount that we could pay while still being good stewards of the corporation, we were coming up $1 million short. And there was another party involved on our side of the equation from whom we needed that $1 million. And despite many efforts among outside counsel, despite a mediation, despite multi-party proceedings, up to this point, we were at impasse. We had not been able to make any progress in closing the gap. Needless to say, we were looking for $1 million, so our position from a negotiating standpoint was higher than that, and they were dug in at zero. And no matter what the mediator tried, no matter what we tried, it seemed almost impossible to get them to budge. So their general counsel, who's based on the East Coast, happened to be coming to Los Angeles. And without a specific agenda, we agreed to meet for dinner. And we had a very nice 2-hour dinner down at LA Live where he was staying. And for the first hour and 50 minutes of that dinner, we didn't talk about the case at all. We talked about life. We talked about our respective careers. We compared notes on the running of an in-house law department. We talked about our families and our pursuits out of the office. And finally, as dessert was about to be served, I brought up the fact that we were trying to get this case settled with their help, and immediately cut to the chase. Look, I've really enjoyed talking to you. I know our outside lawyers and others have been circling around this issue. We're trying to get this matter resolved. And in order to do it, we need $1 million from you guys. And I would say he agreed in about 10 seconds by saying that he appreciated our cutting to the chase, that because we were in a position where both of us were prepared to speak candidly and not worry about the posturing that sometimes goes on in negotiation, they, of course, were concerned if they put any money on the table in the formal dispute resolution process, we would try to nudge that number as high as possible, probably above $1 million. We were concerned that they were going to dig in on a much lower number as they had up to that point. And having built that rapport over 2 hours, I felt comfortable cutting to our bottom line number. And he felt comfortable agreeing to it. Each of us knowing that the other wasn't going to counter, and that having that degree of candor, far from being a problem, actually would help us get to the bottom line, which we did. So I like to call that story the $1 million dinner, and it's just another practical illustration of the benefit of rapport, because we could not have had that conversation if we hadn't spent the time together in person, if we hadn't gotten to know each other one-on-one, talking about things having nothing whatsoever to do with the case. Okay, so let's assume that we've done what we need to do to set the stage for negotiation. We've built rapport. What do we do next? How do we conduct the negotiation in a way that will help us to really understand the other party's position and how we might be able to get to a mutually beneficial resolution? And if you have studied this topic, as I know many of you have, and read the books that we talked about at the very beginning, you'll know that that is often referred to as two things, either active listening or interest-based bargaining. Interest-based bargaining meaning that you're getting behind the monetary position to really figure out what's driving a party in a negotiation and what they need as opposed to just what they're asking for. So, and we see here the definition that active listening helps illuminate the interest in fear or concern or objective behind the other party's negotiating position. And there are a couple different tools that I'm sure all of you have used and seen in negotiations. Paraphrasing is one that is certainly helpful because it reflects back to the other party that you've heard and understood what it is that they're saying. So oftentimes you'll see people in negotiations, whether it's a mediator or a party across the table, say, yeah, if I understand you correctly, and just rephrase, paraphrase that position to signal to the other side that you've heard them. And it can do a couple things. A, it can build trust in the negotiation by letting them hear that you've heard and understood them. Or B, if there is a disconnect, and if for whatever reason you've misunderstood or they've miscommunicated, it gives them the opportunity to correct that in a way that's non-confrontational. So it's a helpful tool. So is silence. Sometimes if you're in a negotiation and the other party conveys their position, just letting a beat of silence hang in the room for a moment might get you information that you might not otherwise get, because human nature is to fill the silence. And if the other side's been speaking and they've conveyed to you what their position is, and you take a beat and let them fill that silence, you may get more information about not only the position itself, but what's behind it, why they're taking a particular position. And that may give you the ability to incorporate that into a dispute resolution that is going to address not only the number that they're giving you or the bottom line position that they're giving you, but the interests behind it. And there are a few different ways to do this. One thing that I think is helpful to remember is that where possible, if you're asking about what's behind another party's position in a negotiation, it can be helpful to avoid starting with the question of why, as in why are you asking that? Why sometimes is a word that's perceived as challenging or skeptical. And if there are any parents on the screen who've ever had to persuade a recalcitrant child to do something that they don't want to do, one of the things you may hear is why. And nobody likes to hear why in the middle of a conversation to that extent. So why, again, sometimes can be perceived as a challenge or an expression of skepticism in what's being said. So there are other phrases that we can use to really draw the other party out and also recruit them effectively into the dispute resolution process. One of my favorites is help me understand, because instead of why, what you're saying is give me some help here. We're all on the same side. We want to get this resolved. And in order to do that, I'm hoping you can help me understand where you're coming from. So that's an invitation to the party to give you a little bit more information in a non-confrontational way. There are other ways to phrase it too, of course. There's some context here that you can share with me. So again, you're trying to get behind the actual stated position and see what's really driving it. If you can get some information that way. And again, you're doing it in a way that isn't skeptical. It's not pushing back on the position. It's just recruiting the other party into the dispute resolution process to give you a little bit more information. Another one is, what's the main problem I can help you solve? So, I hear your position. I understand what you're asking for. What are we trying to address here? And what can I help you do for your clients or your colleagues if we're able to get to a resolution? That's another way to get some information that can help you really understand not only the position, but the interest behind the position. And another one, if you're at an earlier stage in the negotiation, and oftentimes what might happen is there's a reluctance on both sides of the table to go first. So nobody wants to be the one to make the first offer or to make the first demand. And in order to break that ice, without even necessarily asking for a specific number, say, look, I understand nobody wants to be the one to go first here, but tell me what a good outcome for you would look like. What you're doing there is really two things. A, you're drawing out information, but again, you're also signaling that it's not a zero-sum game. Everybody wants to get to a handshake on that transaction or a resolution to that dispute. And by signaling that you are interested in a good outcome for your counterpart on the other side of the negotiation, you're underscoring that we're all in this together. And you want to get not just to an outcome that works for you, but a good outcome for them. One of my favorite real world stories in this regard has to do with a profit participation claim on an old television show that came up when I was working at CBS. As Jeff mentioned at the top of the hour, I've been at Mattel for the last several years. Before that, I worked in-house at CBS Television for many years. And one of the issues that sometimes comes up in the world of television is profit participation, where people come forward and say that they've been promised a share in the profits of a TV show, and they assert a claim for that, and it falls to the in-house team often to resolve it. There was a well-known television producer back in the 1980s whose name I won't share, but who produced a number of hit shows, and evidently, as we discovered, sometimes had a habit of verbally telling people that they'd done a really good job and he was going to give them a share of the profits, a percent on a particular show that they were working on. And so, and we'd heard this come up a number of times. And at one point, and this by this time it was the early 2000s, this producer's former executive assistant had come forward. And it was many years after the show in question was produced. She was already in her 80s. But I believe we were relaunching the show in some form or fashion. And she came forward through a lawyer saying, listen, guys, my former boss promised me a 1% interest in the profits of this show, and I need you to write me a check. And so we began a fairly traditional back and forth negotiation. We realized that the claim from our standpoint was not without some risk. And so we were prepared to settle it. But again, to be good corporate stewards, our tolerance for that wasn't unlimited. And we saw this really as a claim that should settle in the low to mid six figures, given the cost of defense and the risk of an adverse result. The party on the other side, a very delightful woman, was stuck in $1 million, no matter what. And I had a number of different conversations with her lawyer. And I danced around really every way you could think of to see if there was any flexibility there. Look, is there a number in the middle? We really don't see this higher than six figures, but maybe there's a place we can both get to, et cetera, et cetera. And he was adamant. He said, she won't take less than $1 million, no matter what. And that was a number that we couldn't really justify paying. So I finally said, no, listen, I've heard you say $1 million more times than I can count at this point. What's that about? Why is this not a more typical negotiation where there's a little bit of flexibility on both sides? Why is your client absolutely stuck on $1 million? And he explained to me at that point a little bit about her background. He said she'd grown up in the Great Depression. She was somebody who was very conservative with her money. And whatever we paid her, she would put in an interest-bearing savings account at an FDI insured bank, and she would live off the interest. And she had calculated that in order to live comfortably, she needed $50,000 a year. And so roughly ballparking it, if she took $1 million and put it in an interest-bearing account where she could get 4 to 5%, that would generate the $40,000 to $50,000 a year that she was looking for. So we took a step back and thought, well, she's now in her 80s. We had our finance team at CBS run some actuarial tables. And we realized that nobody lives forever. And it was unlikely that she was going to live more than another 10 to 15 years. And so we said, look, we can't justify paying $1 million up front, but we'll settle the case by paying her $50,000 a year for the rest of her life. So from our standpoint at the corporation, we could feel like we were being capable stewards of the corporate treasury because we knew it was highly unlikely that this claimant would live longer than another 10 to 12 years. And so that we could pay $50,000 a year, we'd benefit from the time value of the money over the course of that period. And we also would land at a total number not higher than our valuation of the case. And on her side of the equation, she was getting exactly what she wanted, $50,000 a year. She wasn't looking for a windfall of that million. She just wanted to improve the quality of her life in her retirement years. And without having had the conversation about what was really driving the number, we could have ended up in litigation and having spent more money there on both sides. We ultimately may have had to rely on one of the mediators on screen with us this morning to see if we could get a settlement done. But having had a calm conversation about not just her position, but the interest behind it and what problem we could help her solve, getting back to the language we were talking about a minute ago, or the context that my opposing counsel was willing to share, that's how we were able to get to a win-win for everybody. So when you think about active listening, interest-based bargaining, and eliciting information, not just about a position or the merits of a claim, but about the interest, the concern, the objective behind a negotiating position, often that helps get to a resolution. All right, now let's assume we've done everything right up to this point. We've built rapport, all right? We've had a cup of coffee or a Zoom chat. Maybe we've even gone to dinner. We've sent congratulatory emails on good results and other matters, done everything we need to do there. And going into the negotiation, we've listened actively. We've asked about the interest underlying the parties' positions. We've done everything that we should. But nevertheless, coming back across the table is an unreasonable position. How do we react to that without having the negotiation break down or go off track? And one of my favorite quotes when we think about how best to respond to unreasonable positions, which we have all heard over the course of our careers and undoubtedly and unfortunately will continue to hear. One of my favorite quotes to think about how best to respond is from our friend, the Bard, who talks about responding with a countenance more in sorrow than in anger. So, not getting angry, but being willing to express disappointment. And the question then becomes, how do we do that? What are some practical ways that we can phrase things to signal our disappointment without inflaming things, offending the other party, or having the negotiation break down? Most importantly, it is critically important to avoid pejoratives, as tempting as it might be to say, look, that's a lowball offer. It's never going to work. That's insulting to us. You're being ridiculous or you're being unreasonable. Nothing about language like that is going to help bridge the gap between the parties. And if anything, it could only inflame the tension and have the negotiation break down. But that doesn't mean we need to be pushovers. And we can express our disagreement and disappointment in ways that are not pejorative. So we do that by substituting less heated adjectives. You can say something like, well, that's, listen, we're all trying to get to a deal here. That's puzzling. I hear the number that you're saying, but to be quite honest, that's confusing. I thought we were all moving in the same direction. Again, what you're doing there is confessing the fact that you're puzzled or you're confused. That's not accusatory. It's just descriptive. And if anything, it's confiding that you're really flummoxed by the other party's position and not sure how to interpret it. So puzzling or confusing are less loaded adjectives than insulting, ridiculous, or unreasonable. You can go a little further than that. There's nothing wrong with saying, well, listen, it's deeply disappointing. We were really trying to move in your direction on this and thought we were all on the same page. And, we're disappointed to hear where you are. That's, again, confiding how you are feeling about what you've heard from the other side, but you're not accusing them of anything. You're not calling them insulting or ridiculous or unreasonable or in any way questioning their good faith or diminishing anybody on the other side of the table. Really discouraging is another way to do that. Again, what you're confiding is your own reaction without accusing the other party of anything. Not likely to get us there. Another phrase we can use that expresses sorrow rather than anger. And we also can use questions. What we're trying to do? Obviously, we're trying to get the deal closed here. We're trying to resolve the dispute. What message do you want us to take from the offer you've just made? That doesn't do anything to inflame the situation or derail the negotiation, but it might get you some information. And that's actually, of all of these on this slide, one of my favorites. What message are we supposed to take from this, or how are we supposed to react to this? Because you're ending with a question mark, you're eliciting information, and you may get something. Again, in the $1 million case that we talked about just a minute ago, what message are we supposed to take from this? Can you help me understand this? Without questions like that, I wouldn't have gotten to the interest behind that $1 million demand. And believe me, it was tempting to say, you're being ridiculous. This isn't $1 million case. You're being intransigent, you're being unreasonable, you're not moving in our direction. None of those things would have helped get to a resolution. So what message are we supposed to take from this? What's driving that position? Sometimes responding to unreasonable positions is best achieved by turning it into a question and asking the other side to explain what they've said, rather than just pushing back and ending up, potentially at impasse. So these are just a few turns of phrase that hopefully will keep the pressure low in a negotiation. And also, again, with that question at the end, allow you to elicit some information that may help you see behind what seems like an unreasonable position and inform then in turn how you respond to it. No matter what we do in terms of responding to unreasonable positions and doing all the other things, rapport building, interest-based bargaining, active listening, inevitably, there are going to be emotionally charged conversations, not just in across the table negotiations, but for anybody on the screen who's a manager and needs to manage other people or mediate conflict between people in a workplace. Sometimes people get a little worked up. And the question is how you can deal with that, whether it's in the context of a formal negotiation or another interaction, and see if you can lower the temperature, even in conversations that are getting pretty heated on their own. One thing that is helpful, and I'm sure you've heard this in a number of different contexts, is to avoid using the word but, in the same way that we talked earlier about trying to avoid the question of why and rephrasing your questions in different ways. The minute you say but, you are pretty much negating what the other party has said. So even if you want to validate them and say, I hear what you are saying, but that but's a signal that I'm about to completely dismiss what you've just said. So think about, instead of saying but, saying and. So I hear what you're saying, and I'd like you to think about this. Or, and, what it raises is, a couple things that I think we need to keep in mind as we're trying to resolve this. So we start with the premise that we should butt out, but use the F words. And my guess is that the F words I'm about to share are not the ones that you might have heard come up in heated negotiations. So we're talking about here again, instead of using but, use a less confrontational pivot word. But as we get to the F words, 3 that are very important are feel, felt, and found. It's a great way to validate what the other person is saying, build a little rapport in the middle of the conversation by sharing something about how you once have found yourself in a similar situation or felt the same way, and then what you have found. So you begin by saying, I know how you feel. You're validating that person's position. You're indicating that you've understood the interests. You've done your active listening. You know how they feel. I've felt the same way. And you can share your own experience from other disputes that you've resolved, other negotiations that you've been in, other situations in the workplace that you've encountered that might be similar. So you're pulling something from your own experience and sharing something of yourself. Then you're pivoting to what you've found and kind of leading the conversation out of the heated territory into a place where you hopefully can get to a middle ground. And I've found. So again, I know how you feel. I've felt the same way. And then that requires some elaboration and some sharing on your part, hopefully with something analogous to the situation that the party opposite you is experiencing or expressing. And I've found when I look at it a little differently, or, of course, the similar deals I've found when I, move in the other party's direction a little bit, maybe take a little bit less in the long run, that's more beneficial for my client, things along those lines. So these are just a few tools to think about when you're dealing with rooms or conversations or situations that are heated. Try to avoid the use of but, which can be perceived as dismissive. Think about and instead, and use tools that can personalize things a little bit from your end. I know how you feel. I've felt the same way. And here's what I've found. Now for the grand finale, this is one of my favorites because if we have followed all the prescribed methodologies that we've talked about over the last little bit, we've built rapport, we've listened actively, we've responded appropriately to unreasonable positions, we've kept the temperature cool. Hopefully we are getting to a place where we're able to close the deal or resolve the dispute. The trick on this one is to take yes for an answer. What sometimes happens when a party is succeeding in a negotiation, particularly if they perceive that they've got the leverage, is there's always that temptation to ask for the one thing more. Oh, the other side's agreed to that. Okay, I think just one more thing. You know, when we've got them now, things are really rocking. Let's make the best deal that we can, even if that deal is beyond the objectives that you had when you're going into the negotiation. So it's important at the beginning of any negotiation to have a sense, you know, not only for the other side through your active listening and your interest-based bargaining, but also on your own side about what a good outcome looks like. And once you've achieved that, it can be equally important to avoid the temptation, for lack of a better term, to make too good a deal, because that can have adverse consequences in a couple ways. First of all, it can blow the deal. So if you're in a negotiation, things are moving in your direction, it's all going well, that's great, we've got them agreeing to what we want, there's just one more thing. I've seen situations where that one more thing then is the straw that breaks the camel's back, where one party or the other at that point may say, okay, that's a bridge too far, we've really moved in your direction, we're done here. And at that point, your struggle as a negotiator or mediator is to put the genie back in the bottle and say, whoa, wait a minute. No, you know, we can get back to the resolution that we thought we had before. That's not a good place to be. So if we're at a point where we have a resolution on the table that works for everybody, take yes for an answer. The other thing that's important where possible is to try to create opportunities or approaches for face saving on the other side so that everybody is leaving the negotiation with their dignity intact. Because again, what we're talking about here are negotiated resolutions, resolving conflict and finding common ground, not a zero-sum game. You want everybody to be able to leave with their head held high. And there are a number of different ways to do that. To tell you one little story about it, I'll come back to the slide we had before about the $1 million dinner. So as I told you, we were going into that negotiation, I was going into that dinner, knowing that I needed $1 million. And that from our standpoint was really a place where we needed to go to get that $1 million from the other party to help fund this combined settlement that we were working toward. And after agreeing in principle to the $1 million, my counterpart on the other side really said, listen, you know, I really had a mandate not to go above 6 figures to bring this in. So is there any way we can construe this in a way where our contribution to the settlement is, let's say, 970 or 980, and in a different deal that we have on a completely different matter, we'll move in your direction by another $20,000 or $30,000. And I was perfectly willing to accept that. So it gave my counterpart the opportunity for face saving. He was able to go back to his internal constituents and say, great news, we were able to get this deal done to help Mattel settle this case. We didn't have to go above 6 figures. I was able to get it done for 970. So think about ways, even in a small way, where you can leave a little sugar on the table, leave the other side some face saving, allow your counterpart on the other side to feel that he or she has gotten a good deal in the same way that you have. And that's beneficial, as I said, not only for the particular negotiation that you're handling. So it's not just in the moment. So you avoid blowing the deal by having somebody feel like they're losing face or by adding that straw that breaks the camel's back. But as we all know, the world is small and careers are long, and you are likely to encounter those same people again. Maybe the leverage will be a little different next time. And people remember when you've treated them the right way and when you've allowed them to close a deal or resolve a dispute in a way that they can feel good about. So that's all I had. I'm really thrilled to have been invited to join you guys today. I hope it's been helpful to have, again, sort of a back to basics overview of basic principles that I know all of you implement every day. And I'd be thrilled in the time that remains to answer any questions or have a conversation.
Jonathan, thank you. That was just terrific. And it was both very basic, back to basics, and it was very sophisticated at the same time. I have a couple of questions. Let's start at the end when you talked about take yes for an answer. I and many other negotiators have been in situations where you make an ask. I need $1 million. And then right away, the other side says, okay, we can do that. And the reaction on the part of the one who made the request might be, oh my God, he said yes so fast. Oh, what kind of chump am I? I should have asked for $1,000,001. So when you get it too easily, there may be a feeling of disappointment in your own performance as a negotiator, and whether you've really discharged your obligation to your client to get the best result you can. What are your thoughts on dealing with that?
Very, very good question. I think, yeah, oftentimes there are negotiations that have their own rhythm. And I think there are two thoughts about that. Number one, and again, this is more about preparing for the negotiation than conducting the negotiation, is having an understanding of what a good outcome looks like. So, if I'm entering into a negotiation on behalf of my company, one of the things I will say, if we're going into a mediation to resolve a dispute, or if we're about to sit down across the table on a deal, is to keep in mind what our objective is. Say, look, what does a good outcome look like for us? And then if there happens to be an instance in which you get to that good outcome quickly, you can remind the parties and their representatives, and look, we talked early on about what a good outcome looks like. This is a good outcome for you guys. Let's remember what we said a few minutes ago. We were talking, so I think it's helpful to kind of anchor the aspirations, not just the expectations, but the aspirations going into the negotiation. And the other thing is, and here's where I commend you, Jeff, and all the other mediators on the screen, is reading the room a little bit and knowing that sometimes there are parties or negotiators representing parties who need to go through a process. And that, is just a reality of doing business in this field. And I've participated in mediations as a party representative where, I was willing to get stuff done quickly. It was a case where we thought we could resolve it fairly quickly. I was wanted to move in the other side's direction. And I've had a mediator tell me not to do that so quickly. Say, you know what, look, I appreciate your pragmatism. I appreciate you're trying to get this done. We'll get it done. But the other side's got to go through a bit of a process to get there. If you come up to this number so quickly, they're going to perceive that as a willingness to go higher than you're willing to go. So we're going to have to take this in smaller steps. And just like every individual has their own personality, as all of you know, every negotiation has its own personality. And, it's reading the room and figuring out, okay, this is going to be one that may take a little bit longer. But I think from the standpoint of parties and their representatives, anchoring your expectations, your aspirations, and knowing what a win looks like is important, because you may need to use that as a touchstone if things seem too easy.
And then, Jonathan, does your approach differ if it's a one-shot negotiation versus a negotiation that's part of an ongoing relationship, say with an important vendor to your company?
It can. I think in terms of the fundamentals and trying to maintain a positive tone and a low temperature, hopefully it shouldn't. And I think you don't want to scorch the earth no matter what, because even though it may feel like a one-off situation in that negotiation, things change, and you may find yourself across a table from that lawyer again, representing a different client, or across the table from that party again. The advantage you have if it's part of a broader relationship is that gives you more tools to resolve the dispute. Again, thinking about the case that I mentioned, the $1 million dinner, it was a multifaceted relationship. I needed $1 million. We could get it in different ways. My counterpart couldn't pay me more than 6 figures or contribute more than 6 figures to the settlement. So we were able to figure it out very easily. So the broader the relationship is and the more nuanced it is, the more tools you have as a negotiator or a mediator to bring the parties together. But I always recommend that even if something feels like a one-off interaction, the world works in funny ways, and you need to assume that you may cross paths with these people again.
Yeah.
And if not the parties, then their lawyers, the mediator, etc. And any negotiator is only as good as their reputation.
Now, Jonathan, in the feel, felt, found scenario that you were describing earlier, have you ever had that backfire? For example, if you're dealing with the mediation of an employment case, let's say someone's been laid off and they bring a case against you for age or race discrimination, something like that. And you say, I know how you feel. Have you ever been confronted with someone saying, you know how I feel? I just got laid off. You, Mr. General Counsel, are sitting there in your Italian suit, and we're probably going to go to a fancy restaurant after we eat this, and you're probably driving off in a Tesla, and I don't know how I'm going to put food on the table for my family now. Have you ever been confronted with that kind of a response, and how do you prevent it or deal with it if it happens?
I think it's an excellent point. And I think an important caveat to my little feel, felt, found checklist there is you can only say those things if they're true. So, many of us have not thankfully experienced what it feels like to be laid off or to be injured in an accident or to lose a loved one. And it's very, very important not to in any way diminish the other side's feelings by drawing false equivalences. And so I think that's a very, very important asterisk to attach to that part of the presentation. Those things only work if they're true. And so, there are instances where they do. If we're talking more, taking it out of the nature of the dispute itself and more about how people are reacting to what they perceive as lowball numbers or misbehavior by the other side, that's more of a place where feel, felt, found can work, because you're saying, look, I know how you feel. I felt the same way. When I was in private practice, I dealt with people who were behaving obstinately and making litigation miserable, etc. And I found if I really focused on getting the case resolved, it would work to everybody's benefit. That is a context in which it can work. But to your point, you never want to trivialize somebody else's experience by drawing a false equivalency.
So, Jonathan, now one more question, and we'll have some questions from the audience. You talked about building rapport and having that $1 million dinner and the benefit of being face to face, even if it's only on a screen. And yet we see a tendency in mediations nowadays for people to not to want to be face to face, not to want opening joint sessions or direct communication. They just want the mediator to shuttle back and forth, come up with a mediator's proposal, and hopefully it'll be something with which everybody could live. Are we getting away improperly in the world of mediation from these kinds of face-to-face communications that can develop intimacy and rapport? And what are your views? What can and should we do about that in our professional world?
It's a good question. And I think there are ways to build rapport and maintain in-person interaction even without the traditional joint session. And, I remember earlier on in the development of ADR as a discipline, joint sessions were a lot more common. And the problem was they ultimately kind of devolved into opening statements. And sometimes have the opposite of the intended effect, because, you walk somebody in and they hear how bad they are, and it's awfully hard sometimes to calm them down. And it made the mediators work tougher. So when I'm resolving a dispute for Mattel, we almost always request that there not be a joint session, because A, we don't want to offend the other side inadvertently. And if I'm bringing a business person, I don't want them to be offended and for me to have to spend an hour calming them down and say it's just part of the process. A couple things I think are available tools for mediators that can have the same effect from a rapport building standpoint without the posturing. As you go through the day, sometimes there are issues where you might identify where you realize, okay, it might really be helpful for one side to hear directly from the other, albeit with the mediator present to mediate that interaction. But again, it might have been a situation if, for example, I hadn't been able to resolve that profit participation case that we were talking about. And, if we were stuck, at impasse at like 200,000 and $1 million or whatever, if we'd gone to mediation for that case, and if the mediator said to me, look, I think it'd be helpful for you to hear directly from the claimant's lawyer what's behind her position, because maybe we can get creative on that. So let me bring him in. Why don't the two of you sit down and have a conversation just about that? That's a way to cut through the shuttle diplomacy of mediation and allow for some in-person explanation and interaction, really on an issue by issue basis, where there may be things where you want to say, you know what, I could go back and convey that message, but I think it may be a little better heard and understood coming directly, from the other side. Another thing, and this is less about the negotiation itself and more about the atmospherics and dynamics. If you're going to be mediating all day and you're going to be having lunch in the conference space or wherever it is, that's a good time to bring everybody together, because you're not going to be negotiating. And so rather than say, okay, lunch is here, we're going to bring the sandwiches into your respective conference rooms, and why don't you think about the other side's last position? One thing that's helpful, I think, is to say, hey, you know what? Lunch is here. Let's all, we got it all laid out in another room. Why don't we come grab a chair and grab a sandwich, and we can get back to work after that. And so I think it's helpful if lunch is going to be served, as sort of as trivial as that might sound. I think it's nice to get people together and just kind of have a chat without it being about the negotiation. Same goes for coffee. It's helpful sometimes. I've found in cases where sometimes I've run into the other side, just getting coffee at the coffee machine that's out in the common area. And sometimes it leads to a conversation that actually makes progress in the negotiation. So the more that a mediator can do to bring people together in a way that's organic and not just about the negotiation, I think helps in that rapport dynamic.
Jonathan, some people think that mediators may even say to people, hey, Anschell's getting a cup of coffee there in the corridor. Maybe you're a little thirsty yourself. So, yeah.
Maybe what I thought was coincidental wasn't so coincidental.
David Geffen had a question. David, could you, if you're comfortable, unmute yourself and ask the question?
Thank you for the opportunity. Great presentation, really good basics and things that we really need to hold on to. I find that a lot of times in negotiations, certain types of negotiations, the issue of whether the other side is going to go public with their information comes up, and there's a threat that they're going to do that. And if they do, that could sometimes damage the other side. So it's common for non-disparagement agreements to be written into settlement agreements, but also non-disclosure agreements about the settlement, because you don't want other people knowing that you paid this money, or that this has been an issue that you think may have been resolved already with your company. But I'm wondering, how do you negotiate, and what is an effective way for negotiating non-disclosure agreements?
It's a good question. I think one of the concerns, and this gets back to sort of the taking yes for an answer piece, is that sometimes confidentiality and non-disparagement is left to the end. And, you get to a number and then somebody says, oh, and of course there's got to be non-disparagement and confidentiality. That can sometimes create a bit of a wrinkle. So it's helpful, I think, sometimes to put that up front in the sense that if you're going back and forth on numbers, to put that on the table early. So look, the premise here is we're all trying to get to a place where neither of us will be chest pounding and using this against the other to embarrass anybody. And we also, we want to, do what we can to restore the relationship. So the premise is that neither side's going to be saying anything bad about the other. I think ultimately, and I've seen situations, as I'm sure you all have, where one party may present an agreement where it's all one-sided, where the non-disclosures, confidentiality is one-sided, there's, non-disparagement that's one-sided. It almost always ends up being mutual. And I think it's helpful for the spirit of the negotiation and to facilitate agreement on the other points, sometimes to start with that mutuality. So listen, we all want to get to a place where nobody's disparaging the other, where nobody's trumpeting this as a loss for the other side. So let's assume everything we're talking about is going to be against the backdrop of mutual confidentiality and non-disparagement. Sometimes, particularly as a public company, you may have disclosure obligations to auditors, et cetera. And so you need to make sure that that's understood, that, non-disclosure doesn't mean you can't comply with your obligations as a corporation. But the whole point is nobody's going to be embarrassing anybody else. And the sooner that you put that out on the table and the sooner that it's mutual, the better off you're going to do.
David, thank you for your question, and Jonathan for that answer. And Jonathan Anschell, I want to thank you very much on behalf of Natalie, Jean, and myself, and everybody listening here and who will be listening to the recording of the presentation. Thank you so much for a terrific presentation, which was both basic and advanced at the same time. I hope that people, if they're in a position to contribute, will contribute to the SOVA Food Pantry here in Los Angeles, California, where we live, or another food pantry that's important to them within their own communities. Jonathan, in summing up, all I can say is I'm going to paraphrase one of your slogans, company slogans from way back when I was a kid. We can tell you're Mattel, you're swell. Thank you for a great presentation. And with that, we are complete.